The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This morning we have 4 cases that are going to be submitted to the court, 2 by oral argument, 2 without oral argument. The case of State versus Shane Davis is hereby submitted without oral argument, and the case of State versus Wilborn is hereby submitted without oral argument. We will begin this morning's oral arguments with State of Iowa versus Kraai. I believe counsel look like they're ready to go. Okay, Ms. Wingert, you may go first.
May it please the court, counsel. I'm here today on behalf of Kraai, who seeks a new trial because of a jury instruction the Court of Appeals found flawed, but they decided that it was not an error that harmed him and so did not order a new trial. They did find, though, and I'd like to address both issues. First, the jury instruction, which was inappropriate, and then also why it was not a harmless error. The jury instruction provided that there's no requirement that the testimony of a complainant of sexual offenses be corroborated. We believe that that flies in the face of Iowa Code Section 709.6, which provides that no instruction shall be given in a trial for sexual abuse, cautioning the jury to use a different standard relating to the victim's testimony than that of any other witness to that offense or to any other offense. In this case, then, there was a child who did testify about certain acts involving her father, and the father testified also that those things were not true.
It doesn't violate the statute. The instruction doesn't tell the jury you should apply a different standard, does it?
It does when we have the testimony of the defendant. Also, the instruction doesn't say his testimony doesn't need to be corroborated. It says only that hers did not need to be corroborated, and I believe that is a different standard than what trial counsel asked for. First, that there was no such instruction, but then also asked that there would be parity, that Mr. Kraai's testimony would be treated the same as hers, and it wasn't with this instruction, basically bolstering her testimony over his.
Different issue. I mean, maybe it's not a violation of the statute, but it highlights her testimony, or it puts maybe undue emphasis on her testimony. But it seems like the legal standard is the same, which is neither witness's testimony had to be corroborated. Is that fair?
I think that's fair that could have been an instruction that might not have caused as much harm, perhaps, as the one that was approved here. But I do think that it is a comment on the evidence that isn't applied to victims of other offenses, that it's the one that the state has sought in only as to victims of this kind of offense, that they want to basically lower the reasonable doubt bar when it comes to a sexual offense. And I think that does violate the statute because it does apply differently when it's applied to sexual offenses versus other crimes where a victim might testify and not need corroboration.
At least suggest that other witnesses' testimony does need corroboration?
Because it's a comment on the evidence, it sets her testimony apart from others in a way that the statute, I don't think, provides. And also, Mr. Kraai was entitled to present his defense, and that his testimony should have been viewed equivalently with hers, that it shouldn't have been set apart in the instructions as less credible than hers. That statute was adopted in the 1970s at about the same time that this court had its Feddersen case, getting rid of the Lord Hale instruction, which had been criticized as a comment on the evidence, as treating the credibility of a victim of a sexual offense differently than that of others. And also at that time, there wasn't clear direction on when that Lord Hale instruction should be used. So I think we've come a long way since the 70s. But in this way, the state seems to be saying we should now, instead of that higher bar that Lord Hale required, we should have a lower bar, and that the victim's testimony should be treated differently.
should that statutory history and the Lord Hale instruction inform our interpretation of the statute? Meaning, it seems like the purpose of the statute was to codify recent case law that the witness shouldn't be disadvantaged.
Disadvantage, yes. But as far as looking at the statute itself, I think the language of the statute is plain, and that we don't need to look at that history to try and interpret it. It says no different standard should be used, and I think that's clear, that it shouldn't be a higher standard and it shouldn't be a lower standard, as has been urged by the state.
Of the state's recitation of voir dire questions, where it looked like jurors actually did sort of have this Lord Hale instruction somewhat permeating somewhere in the background. Is it justified based on, in this case, those questions and the answers to them?
It was justified, Your Honor, based on those comments. I think that was something that's covered by the general instructions that say we should give each witness's credibility what we think it deserved, what we can believe all, part, or none of what their testimony might be. I think those general instructions are sufficient. They certainly don't require corroboration for her testimony or for anyone else's. And that those answers by some of those panel members on when the jury was selected, I don't think mean that those final jurors would have kept that view. It was certainly something that the state tried in argument and in voir dire to try to dissuade them of. The state, in their final argument, was very clear that they were basing this on the credibility of the witnesses. It was a test of credibility between what she said and what he said. Only two people knew, they argued, about which was true and not true. And so I think that certainly the way it was tried would be something that we can consider when we determine whether that was appropriate. It was definitely tried as a test of credibility between those two witnesses. I think the trial court should avoid arguing on either side, either for the complainant's testimony or for the defendant. And this instruction was an unfair comment then on her testimony. As the Court of Appeals noted, that the state would read the 709.6 to ban something that would raise the bar of reasonable doubt, but it provides that there's no different standard, and it should also bar any lower standard that the state might want to use. It's also, corroboration may be a word that's not in common parlance for a lot of jurors. The instruction didn't provide any context or any explanation of what that might mean.
For what that might mean?
I think that any comment that we might make, I know there have been different kind of formulations of that, kind of a more elaborate instruction in Altmaier, one of the prior cases, versus Barnhart in this case where it was more simple. I think however it might be formulated, it still is a comment on particular evidence that's inappropriate for the court.
You're raising kind of two arguably separate arguments. One I get, and that is that you say the instruction has given unduly focused on the witness's testimony, the victim's testimony. I get that. But there's a second potentially independent argument that is, well, nobody knows what uncorroborated really mean. I mean, it sounds like a corroded battery or something. I mean, I don't know. But I think it's incumbent on you to suggest an alternate approach to corroborate the word. Use of the word corroboration. I'm asking you whether you had such below.
I think that if there was some instruction about a witness's testimony didn't necessarily need to be supported by other evidence, something like that, if applied to all witnesses, I think that that could be something that may aid the jury, that they could consider that witness's testimony, any witness's testimony, whether or not there was other evidence to support it if they believed it beyond a reasonable doubt.
Support be a substitute for corroboration and more easily understood. What do you make of the state's argument that the court's general instructions, solve the problem. We read instructions as a whole, and then they're told to, consider whether there's inconsistencies, apply your common sense, a variety of general instructions. Does that solve the problem?
Of the problem when that particular witness's testimony is set apart with this kind of specific instruction. Here, it wasn't a person named specifically. It had been in the Altmeyer case. Her initials were used. I think it's clear, though, whether or not the person's named. It's clear who we're talking about there and that her testimony is to be treated differently under this kind of instruction. And so we do believe that Mr. Kraai was harmed by the inclusion of that instruction. There were only 2 people, according to the arguments, that knew the truth of the matter, and that this set her testimony over his. There were comments about other knowledge that she may have had that was inappropriate, certainly, but as to the actual offense, there was nobody else who provided any testimony about whether that occurred or not, other than Mr. Kraai and his daughter.
To say that this instruction, kind of tipped the balance or even had the potential to tip the balance in a case where there certainly was other evidence, the pornography and the penis ring and things like that, isn't that kind of a hard sell?
I think it is, and I think that is probably part of why it was error here and not harmless, because the state's concerned about kind of a historical view of treating the victim's testimony, more especially because of a bias maybe against them. I think there's certainly bias in our system today against somebody like Mr. Kraai, who's accused of a crime involving a child, in this case, his child. And so we shouldn't swing in the other direction then, that it wouldn't be, that the jury should fairly consider his testimony. He wasn't a good parent. I think that was clear from the evidence. He wasn't very private about his privates, would go about his household with holes in his pants and lacking underwear and that kind of thing. And so it certainly seemed there could be other explanations. The pornography, that certainly a month after her last visit, when they came to do the search warrant, certainly in plain sight, and it seemed to be that was the case previously also. So I think there were alternate explanations. Again, I think it is a hard sell given his circumstances and the accusations against him. But when we have the court saying that her testimony is special, and we have the test of credibility between her testimony and his, that does provide plenty of reason to believe that the error was not harmless here. We have a presumption, since the jury instruction was challenged, we have a presumption that there was error, and that would be something that he would be prejudiced by, that this conviction was not something that was surely unattributable to that error in the instructions. Other cases where this non-corroboration instruction have been considered have maybe had more than one victim or more than one witness testifying about that. True in the Barnhart case or Altmeyer. More recent, Iowa Court of Appeals cases, both Mathis and Atkins, more than one child involved, more than one child testifying. And so I think those other harmless error decisions may be appropriate, but here for Mr. Kraai, we have not only just one person testifying about the allegations, but we also have the testimony of the defendant opposing that, and that his testimony should be considered fairly, equivalently with hers. That wasn't done in this case. If I don't have any other questions right now, I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Madam Chief Justice, and may it please the court. Counsel, good morning. It's good to be here with all of you. Let's start with something that we all agree on. This instruction is a correct statement of the law. The state is not arguing, and I don't think has ever argued, that a lower standard should apply to evaluating a victim complainant's testimony.
Though, quite frankly, you have a specific instruction with respect to the victim not needing to be corroborated. The suggestion is made, well, I mean, that's true enough, but when there isn't an express statement that that principle applies to others, you know, a jury could come away with the implication that it doesn't generally apply. And further, I would say this, the closing argument troubles me here because I think the state, you know, concentrated largely on the fact that the testimony doesn't need corroboration. So don't we have a problem here because of the implications of the express statement?
No, I don't think so, Your Honor. Now, I would suggest that before this court ever says that jurors would draw an implication from exclusion by omission, before you ever do that, remember that the jurors are instructed that no one instruction contains the applicable law, that they should read all of the instructions, and that, in fact, Iowa law says that we presume jurors take the instructions as a whole. So before you ever draw an implication from exclusion by omission, or before you ever say jurors would do that, first, read the rest of the instructions too. And I'd suggest that the way to approach this is there a sentence somewhere else in the instructions that, if you put it right there in that same instruction, would solve the whole problem? If so, we presume the jurors considered all the instructions together, so the instructions as a whole aren't inaccurate or misleading. So you have jury instruction number 9, which says give all the evidence the weight you think it's entitled to receive. You have jury instruction number 10, which says decide what testimony you believe. You may believe all, part, or none of any witness's testimony.
Actually cure the specific defect here. So if you instruct the jury to give the evidence you think it's entitled to, but a different instruction says that this particular witness's testimony doesn't need corroboration, but doesn't give that same instruction with respect to other witnesses, it seems like it's just amplifying the error.
So I think, as was observed earlier, these are actually, there's kind of two separate claims, that one, that it violates the statute, and two, that it emphasizes or does this by implication. Now, what this instruction just says is there is no different standard. There's no corroboration requirement. Now, you could say that, if this were the only instruction, then maybe you could say that it implies that there is a corroboration requirement for other witnesses' testimony. But the other instructions say the jurors get to decide which testimony to believe, any, all, part of any witness's testimony. It says, it explains how to apply the burden of proof beyond a reasonable doubt. And now,
testimony to believe. With respect to one witness, the instruction says corroboration is not required. And then the instructions are silent as to the remaining witnesses. It would seem like the jury would think that this witness is different somehow. So as we're evaluating whether to believe her testimony versus other witnesses' testimony, that her testimony is somehow different. I mean, there's nothing that tells a jury that's not correct.
same instruction. To do that countermands all of our cases saying that juries consider the instructions as a whole. In fact, they're actually instructed to do that. And that if the instructions as a whole accurately and correctly explain the law, then there's no error. This is part of
The instruction your colleague recommends in his law review article. The first sentence says you should evaluate the testimony of the alleged victim the same way you evaluate the testimony of any other witness. What if we added that at the beginning and said that's, if you're going to give the corroboration instruction, you need to put that sentence in front?
Now, what this court is here to decide in this case is, was this instruction correct? And I think it was a correct statement of law. I'd add that, when you go back to the transcript starting at page 218, there's a ruling from the district court that it's going to give a non-corroboration instruction. And it actually has more language initially. And then there's discussion between counsel about what the wording should be. There's never another ruling from the district court after that. And actually the district court says, Mr. Defense Attorney, what wording would you like? And the defense attorney gives their preferred wording. So that's I think error is preserved to say you should not give a non-corroboration instruction. I don't think error is preserved to say This particular non-corroboration instruction had a unique defect based on the language chosen that made it wrongful.
Additional language? I mean, if it didn't have the implication, you wouldn't need the 10 words that they wanted to add.
Is that ask for additional language made? Is it ruled upon? It's not. The court says, Mr. Sarcone, what language would you like? And he reads the sentence that becomes the jury instruction. So now, Justice Mansfield, this court can say the language that it would like given in future cases if it wants. And I think it might clear up confusion over what the best version is to give.
Assume it's kind of a stinky instruction, just for the purposes of discussion, and maybe it shouldn't have been used. I'd like to hear what you have to say about the harmless error. If it was an instruction that maybe should not have been given.
So I'm going to start with harmless error. By the time we're in harmless error, I'm not talking about the rest of the jury instructions anymore. Because if you find the other jury instructions fixed it, then the jury instructions as a whole aren't misleading or inaccurate, and there is no error. So for harmless error, I'm talking about the arguments of counsel, and I'm...
No error, right? Okay. Either way, either argument.
The arguments of counsel, and I think Ms. Wingert pointed this out, counsel accurately identified that the jury gets to determine whether they believe the witness's testimony, whether they believe the defendant's testimony, gets to determine what they believe happened. Just as the jury instruction said, your duty, I believe that's number 5, your duty is to decide all fact questions. And the other jury instructions I've already mentioned. So there's no way to say that the closing arguments conveyed some sort of implication from this challenge jury instruction that, look, you should apply a different standard than you would to any other witness's testimony, or that you have to believe the victim.
About that, but if a more balanced instruction had been given in closing argument, the defense would have had the opportunity to say, well, neither the defendant nor the prosecuting witness needs corroborating evidence. It's a common concept. It would have balanced things a little more, maybe, if there was the express language. Counsel always, well, not always, but frequently cites jury instructions in closing to the jury, of course, and the defense would have had a stronger argument if there was a specific balanced instruction.
So, Your Honor, and I think the defense was still free to say, you can believe the defendant's testimony, it doesn't need to be corroborated. Now, if the defense, again, we're in a universe where the language used was the language that the defense requested, but I don't think that the defense was precluded from making that argument that the defense testimony should be believed, and that it doesn't, if you believe his testimony, you don't need anything else to find that this didn't happen. They could make that argument, and I...
True, but they don't have the jury instruction to back them up at that stage.
When I hear that, all I'm hearing is a good explanation for why an instruction like this is needed. That people say that the prosecutor can tell the jury that they don't need anything beyond the complainant's testimony, but beyond the victim's testimony. But the jury needs the law to apply, and if they get back and they're confused about, if I believe the victim's testimony, does that establish proof beyond a reasonable doubt? If they're confused about that, nothing that the prosecutor said in closing arguments will help. The jury instructions need to resolve that for them. And I think there's a pressing need. I think the voir dire in this case illustrates it. I think that the research illustrates it, that Section 7096 is great, and I think it should be followed, but it...
The outside research that you talk about, are we permitted to look at that and to use that in our cases?
At this point, I would be very surprised if you weren't. This court gets to decide, the parameters of its review. It would be consistent with how this court has handled similar issues where it needs to decide, is there, based on the facts on the ground, based on things we know about our society, it's almost a policy or legislative judgment of, is there a need for this? Now, you could say that we require a fact-specific, adjudicative fact showing to support the giving of this jury instruction in every case, meaning present testimony and evidence and social science in the jury instruction conference. that's not the approach that we take for implicit bias or eyewitness identification instructions. As long as we're talking about other instructions that we give, the idea that this highlights the complainant's testimony or emphasizes it, I don't think it does that. I think it references it. We have jury instructions that say, you've heard.
You mentioned voir dire in this case. When I read that discussion between the state's counsel and the jury panel, it seemed that they were just interested in testimony generally, not being evidence. It wasn't specific to the victim. And so when I read it, I didn't see a need from this particular panel to highlight the victims as opposed to, I know that the state certainly identified the victim, but when I read through it, many of the panel members were more interested in just whether or not testimony itself can be evidence. So doesn't that kind of support the idea that that with respect to the defendant's testimony, that it would have been better to have instructed kind of equally on that ground?
Well, some of them did. Some of them, you're right, did say, I don't know that evidence or testimony is evidence. But even after that was explained, some of them, one of them even said, I could believe a person who testified that a defendant shoved them while walking down the street without more evidence, but I would have trouble believing a child's testimony about sexual abuse without other corroborating evidence. That's at page 45 through 46. And I actually believe that person ended up on the Pettit jury. Now, yes, and this is consistent with the research, showing that for some reason, it's different. For some reason, people in our society have trouble moving beyond the starting point that he said, she said is a starting point for a jury. And people have trouble accepting that they have the authority or ability to decide what they think happened, specifically in sex abuse cases or rape or sexual assault, when confronted with that. And now I think that
Look at social science research as we have. Some of the stuff in your brief is a little bit dated. Is there new social science on this whole push to believe the victim that we heard in the Justice Kavanaugh confirmation hearings and related social commentary? Does that push back against you can't trust, concerns about false allegations of rape today? Is it more, you believe the victim?
I don't have more recent research than we cited in the brief in the application for further review. I would say that these kinds of societal, now I've heard that things have changed a lot since the 70s. The voir dire in this case, I think, is Exhibit A, that's not entirely true, that these attitudes are very sticky, that they tend to, and it's not just about, news and political discourse, it's about the way our society is structured and the fact that sexual activity happens in private, in the shadows, and that there's, So I think my short answer is, I don't think that it goes away so quickly that now, and I think 709.6, it's correct. I don't think we should be saying that there's a lower standard that applies to victims, but I do think that we still have a need for instructions that say apply the same standard or don't apply a higher standard. And even without any of the research, even without voir dire, we've still got that statute. It would still be correct to give an instruction that states the applicable law, that you should evaluate you shouldn't apply a heightened or different standard to the victim complainant's testimony. And so I don't think that you even need any of the research or the voir dire to get there. Now, Madam Chief Justice, you asked me about harmless error, and I talked about the attorney arguments. I also think the facts here are extremely strong to establish harmless error. The pornography that was found just as the victim described, the pants with the hole that were found as the victim described, the victim's vivid description of things that are beyond the ordinary experience of a child of her age with regard to how the defendant's penis felt, the description of the ring, regardless of what you think about the placement of the ring, she describes that it exists, and she described seeing and touching it, and then it turns out that yes, he does have a ring, and so I think the inferences that we argued in our brief are fair and accurate, but even if you want to argue about the placement of the ring, it still exists, and that alone is extremely probative. And I think that reading her testimony as a whole, it comes across as extremely credible. Now, just to get back a little bit to the argument about implying Oh, I'm sorry, my time's expired. I'll save all of that for the rebuttal. Thank you.
Did want to address a couple points there. As far as the preservation of error, Mr. Sarcone did suggest some alternate language, but he also said that he would prefer that the instruction wasn't included. I think that's preserved. Certainly didn't preserve the plural as the Donahue case addressed, but as to the inclusion of the instruction and the overall propriety of it, that was preserved. Also wanted to address the question about whether the voir dire showed that this was something that was needed. I think there have been a lot of changes since the 70s, certainly recall those days, and I think that there has definitely been a swing, Me Too movement and other things, to listen more carefully to victims, and much of that has been positive. I think if it swings too far, though, which we believe it did in this case, where the defendant's testimony can't be fairly considered, I think that would be something that would be too far and would be a violation of that code section. There certainly wasn't any record made as to any social kind of research that would say that this jury in Sibley that day wasn't able to fairly consider. I know that also in my experience, I've had people say that it's not evidence, someone's testimony. I've heard that within the last week in the context not involving anything regarding sexual abuse, that some people believe that what somebody says about what happened isn't evidence that a jury may consider against them.
It's just kind of looking at some of the standard criminal jury instructions, and one of them that is available is to benefit the defendant is an instruction on eyewitness identification that it basically singles out the eyewitnesses that are presumably identified the defendant and says, you know, here's a consideration, here's a consideration, here's a consideration, here's a consideration. I mean, so, and that's meant to rebut or at least caution jurors about the common viewpoint that about the reliability of eyewitness identification. So what's wrong with that? The defendant gets the benefit of that. What's wrong with the state being able to caution jurors about another common misperception?
I think if it was a common misperception that they felt needed to be addressed, and it had been addressed as to all witnesses, I think that we would be in a very different circumstance than we have here.
If we added the first sentence from the Tyler Buller article, the proposed instruction there.
As long as the instruction doesn't go on to specify the victim's testimony or the complainant's testimony or this named person's testimony, if we have something that says just that any witness may be believed without any supporting evidence, perhaps. Thank you.
I just have just a quick point. So one more thing about the exclusion by omission argument. To the extent, now there, you know, in Davis, the exclusion by omission problem was that they had other jury instructions that applied that defense, and they could compare, you know, this instruction doesn't apply it and this instruction does. Now, in this case, even if you think the jurors would look at it and be like, should I apply a corroboration requirement to other witnesses' testimony? Then they would look through all the other jury instructions and say, well, we weren't instructed on any corroboration requirement. Corroboration was never even defined. You know, even if they tried to look for that, which I don't think they would, but even if they did, they wouldn't end up applying a different standard because they weren't given a different standard to apply. So I think that not defining corroboration is the right move for an instruction like this, because that.
Each question, Mr. Sloven. I know you filed like a cross application for further review, but you're supporting the ultimate decision of the Court of Appeals. You just disagree with the rationale. Is that something that a party is allowed to do?
I think so. I think that the rules say a party may seek further review. I don't think it specifies it has to be the losing party. And otherwise, I mean, this opinion would evade the state's opportunity to get review of the rationale saying that this instruction was error. and it's important enough that the state had to seek further review, notwithstanding the result.
Your distinction of the Davis case, that makes sense. But what about kind of a specific versus general argument where this is one instruction specific to the child victim or the complaining witness? Wouldn't a juror naturally give that, I mean, say that trumps the general instructions about every other witness or all other evidence? Doesn't it still leave us with this misleading by omission problem?
Standard to apply, then maybe, but it says there isn't a different standard that applies. And I think that what it really does is directs the jury back to the general instructions to evaluate the complainant's testimony. It doesn't give them a different way to evaluate it. It just says there is no different, now, and I want to say, to reference the testimony doesn't unfairly highlight it. Milliken, the problem is that the court said, in considering if the defendant is intoxicated, you can consider, and then lists a bunch of facts showing that tending to show the defendant was intoxicated. The Lord Hale instruction was a comment on the evidence because it said, hey, here's our, rape is easy to allege and difficult to disprove.
Maybe turn this around and not make it be about sex abuse. Instruction 12 has to do with expert testimony, and it's, in my opinion, the vanilla version. There's nothing unique about it. It says you've heard testimony from experts. Any other testimony, you may accept it or reject it. It's a normal, generic one. And then let's just say in that case that there was allegations of domestic violence and all that business, and there'd been an expert on the cycle of domestic violence. If there had been a separate instruction all by itself, there's no requirement that the testimony of the domestic violence cycle expert be corroborated. Wouldn't that be weird?
I think
Too.
It wouldn't be supported, it wouldn't find support in section 7096 for one. It wouldn't be, it would have nothing to do with our experience, both voir dire in this case, generally by the research.
Just in general, I don't think it has to do necessarily with this particular, like a victim. We seem to be focusing a lot on victim and Me Too and all that business. My point is, it's an instruction that's general about a certain type of witness, and then there's an individual one that pulls one witness out. Doesn't that kind of shade it, maybe contrary to what you're arguing?
That would be strange. I think your instruction or your question contains the distinction that I want to draw, that this is about a class of evidence. Right now, in this case, there was just one witness's testimony in that class, the complainant describing sexual abuse. If there had been more, then it would apply to all of them. I think that the fact that it doesn't say a different way to analyze it is the thing that I think makes this not a violation of 7096 and gets rid of the possibility that the jury would take this instruction and say, I need to analyze this differently. The instruction says there is no different analysis to apply for this witness's testimony. And when they're looking for ways to evaluate the evidence, they're left with nothing but the general instructions about how to evaluate all witnesses and decide what facts they believe and how to hold the state to its burden of proof beyond a reasonable doubt. So I don't think the instructions as a whole were in error, and so I would urge this court to affirm the result, but reverse the reasoning given by the Court of Appeals. Thank you.
Kraai is hereby submitted, and we'll allow the attorneys to make a change, and we will get ready for State versus Stevens.